New Year greetings to all our viewers. Welcome to the January 2024 edition of Caribbean Calendar. I'm your host, Ingrid John Baptiste. We are continuing our season with topics that are of interest to you, our viewers. I will be speaking with Stéphane Montpremier, an attorney at law with a practice in the Ottawa area. He will demystify the all-important areas of powers of attorneys and wills, which are two topics of importance that many of us have made a concerted effort to avoid. Stéphane is a lawyer, mediator, and arbitrator. He has been practicing law in Ottawa since 2002. He has spent over 2 decades litigating complex family law and estate law matters in the Superior Court of Justice of Ontario. His law practice is now focused on estates, including estate planning, estate administration, wills, powers of attorney, and probate. Stéphane, thank you so much for agreeing to come on Caribbean Calendar. And it's a real pleasure to have you. I know we have so much information to share, so let's get right down into it.
Thank you for having me.
Could you first give us a layman's definition, for want of a better word, of these two documents or areas, powers of attorney and a will?
All right. I'm going to try to explain these documents in a way where I just want the public and the audience just to get an understanding of what it is. And the will, powers of attorneys are documents that take effect while you're alive. So they govern. By preparing a power of attorney, you're the person that you name as the attorney in the document. So usually a trusted person, very often a spouse or a child or a very, very close friend, an aunt or uncle. You're giving the power of that person and the authority to make decisions on your behalf relating to your finances. That's for the power of attorney for property. And there's a second power of attorney called the power of attorney for personal care. So you're also, in this document, you're giving the authority to the person to make decisions relating to your health and in the event that you're incapacitated. So wills, so we have wills, right, which is the document that we're a little bit more familiar about. A will is a document that takes effect in the event of your death. So in a will, the will is a document where you're designating who is going to be the beneficiary of your estate, of your assets, and you're also naming someone who's going to be responsible to administer your assets. So a will takes effect at the time of your passing, after you've passed away, and powers of attorneys take effect while you're alive. So powers of attorneys is, I see clients using powers of attorneys when, for example, there's been a stroke, right? So the person is still alive, but they suffered a stroke. They're in the hospital. Maybe they can't speak. Maybe they've lost the capacity of part of their body. They may have to do physiotherapy for a long time. So they can't go to the bank. They can't go on the computer and type in their passwords and pay their bills and so on and so forth. In some cases, the stroke patient or a patient who has recovered from or is still recovering from major surgery doesn't have the capacity to give verbal instructions to the doctors. So if the doctor is asking, okay, well, we have 2 or 3 different procedures that we can choose, which one is in the best interest of the patient? Well, the patient may not be, and the patient might be your mom, your dad, your aunt, your uncle. The person is not able to give instructions to the doctor, and so the doctor needs to have a document that gives someone the authority to instruct him or her and to make the decisions.
So that has to be done quite clearly when you're normal, you're not ill.
Yes.
Right.
So that's very important. That's a very good question or comment regarding powers of attorneys and wills. Once you've lost capacity, so once you've I hear a lot of clients and family that deal with me or that I assist, will call me and say, "Oh, Dad's been diagnosed with Alzheimer's. Mom's been diagnosed with dementia." Right? If the diagnosis, if the person's been diagnosed, or if they've reached a point where they're no longer coherent, no longer able to comprehend the nature of their decisions, it's too late to prepare the power of attorney and the will. So it's important that we get these documents done while we're healthy.
I had that question for later, but I can ask you now. What happens in that circumstance?
The circumstance.
Does the government or someone step in to take care, or that's?
It's, I would say, in my experience, I've been practicing law for 22 years, and in my experience, not having valid powers of attorneys is more, it can be more of an administrative problem than passing away without a will, because I've had a number of files where someone has suffered, and sometimes they've suffered an accident very young in their lives. A person may be 40, and there's a car accident, and there's no power of attorney. You can, if you have an accident and you may live a long life, you may live another 20, 30 years. But without a power of attorney, what the family has to do is they have to go to court and get a guardianship order giving the authority, get an order from the court authorizing the members of the family to make the decision. And that process takes a very long time. It takes 3 to 6 months, and it costs several $1,000s. And we also have to appoint the Office of the Public Guardian and Trustee, the Province of Ontario, who will have the possession and control of the person's assets until the court has nominated someone else.
Okay. All right. So let's take a will, for example. What are the steps involved in preparing a will? What would I have to do? What would I have to come with?
Well, different lawyers in law offices have different practices. My practice is, because I deal a lot of my clients are employees for the City of Ottawa, police officers, nurses, federal government employees. And so my average client, I do have business owners and professionals, but my average client will have a house, maybe a vacation property, pensions, RSPs, maybe some TFSAs, some checking and savings accounts, maybe a few vehicles, sometimes even a property in like a place like Florida or something like that, or Key West. So for these types of estates, which I consider fairly simple estates, I'll normally have a meeting with the client, and I will ask a number of questions to ascertain, okay, well, I want to get a sense of what the person's assets are, what their liabilities are, so what they own and what they owe. I'll also want to know if there were any previous marriages or divorce, and if they have any dependent children, because that impacts the estate plan, and whether also, because sometimes people have separated, they've moved on with somebody else, or they're single, but they have existing child support or spousal support obligations, right? You may be separated, but you still have to, if you have to pay $1,000 a month in support for the next 10 years, well then we have to take that into consideration when we're making the estate plan. So usually, the information that I need to properly advise my client is usually provided by my client in our internal will and power of attorney questionnaire. So that's a document that I've crafted over the years, and I try to make it, the questionnaire is very short, because I want my clients to, there was a time when I had a very long one, several pages, but now I've managed to synthesize the essence of what's important into one page, and I ask questions, and then once you provide me with that information, then I know how to ask more detailed questions, and then we speak, we discuss, we exchange, and then we prepare a draft will and draft powers of attorneys. I send them to you for your review. And sometimes sometimes there's things that we have to adjust. It may be, there's 2 N's in her name, or things like that. And at other times, by engaging in the process of preparing these documents, I find that people will start to think about things that they hadn't thought about before, right? And then you might have a conversation with a girlfriend over coffee, and she'll tell you something that happened to her family, and then you, oh, maybe I should do this or maybe I should do that. And then the clients will come back to me and say, well, Stefan, what do you think about this? And what do you think about that? And then I'll look at, we'll discuss it, and we'll discuss things like family dynamics. I have several, I have several clients who have, someone in the family that, is a good person, is smart, but may have a mental health issue or maybe a substance abuse issue that prevents them from being able to take care of themselves, or you may not feel comfortable entrusting them with a large amount of money. You may want to name someone to manage those funds on their behalf, right? To make sure that they have a roof over their head as long as they're alive, right? So there's a ability to set up special estate planning tools when we have families that have special needs.
Because I know there are kids, so, I've spoken to people who've said, oh, well, they're will kids, I don't need a lawyer or whatever. What an honest opinion of will kids?
Well, I'm a lawyer,
Yeah.
so I'll give this analogy or metaphor to clients when I'm asked the question, but I'll give you an answer as well. I'll say, well, you could probably watch some videos on YouTube and change the brakes in your car, but if there's a mistake that was made, the consequences can be pretty, significant.
Right.
And so I'm of the school of thought that if it's something important that affects that may have an impact on what you've managed to accumulate over your entire life, and that will have an impact on how difficult it will be difficult or easy it'll be for your children and your family members to grieve, I think it's worth an investment of a small investment to make sure that once you've passed, your family members can focus on grieving rather than being in court for 2-3 years to resolve, to sort of clean up the things that you didn't get a chance to clean up during your life.
Okay, I want to go back to the powers of attorney because it seems to me that is the area that we are less familiar with. So you indicated that there's a power of attorney for your finance. Mm-hmm. And a power of attorney for your health.
That's correct.
Would it be the same person who is in?
That's a good question. So the power of attorney for property, right? I'll usually recommend to clients that they appoint someone they know is financially savvy, someone that has been good with their own finances, someone who's maybe not too emotional, someone who's relatively stable, And the power of attorney for personal care, well, then you want to appoint someone that you find nurturing, that is maybe more sensitive to health issues, has good bedside manner. And so, think of your family. In every family, there's members that are really strict and orderly when it comes to their money, right? And they're very meticulous with their money. That would probably be the kind of personality type you want to appoint. Someone as your power of attorney for property. Your power of attorney for personal care, however, it may be another person, but the reality is, in most cases, it's the same person. In most cases, spouses appoint one another, and then you appoint an alternate who will act in the event that your spouse is unable to, or your child, or someone else. Right?
But it's interesting you said that, because wouldn't the power of attorney, the person in charge, be carrying out your wishes, though? What would be reflected in the power of attorney? Isn't it what you want?
The power of attorney is, with the power of attorney, the person could make any decision that you could make if you were capable of doing so. So the person can, I often see powers of attorneys used if someone is sent to let's say a retirement home, and the home has to be sold.
Right.
Now the person who's appointed as the attorney can sell the house. Now one thing I should say is that powers of attorneys normally should to be activated. So you can sign a power of attorney. You can sign a power of attorney today. It doesn't necessarily mean that document is activated, because to activate the power of attorney, typically you'll need a letter from a physician or from a capacity assessor to confirm that you don't have the capacity, whether it's physically or mentally to make those kinds of decisions on your behalf. And the power of attorney prepared by the lawyer, along with a document or a letter from a physician confirming that you're unable to act, will then give the authority to the institution, whether it's a hospital or school or Rogers or utility company, to make decisions, to accept and allow the person to make decisions on your behalf.
What happens if you die without a will?
If you die without a will, well, there's a lot of horror stories about what happens if you die without a will. I mean, there's the Succession Law Reform Act, which is a provincial law in Ontario, which governs what happens to your assets and your estates if you die without a will. It adds complication, it adds expense, it makes the administration of the estate and the probating of the estate. So administration of an estate and probate that's the legal process that takes place in court after someone's passed away. And the probating, that process will ensure that all the debts are paid, all the taxes that the estate has to pay to the government are paid, and the assets are distributed in accordance with the provisions of the will. So that process is a lot, if there's a will. That process is more complicated, more lengthy, more costly if there's no will. When there's a will, it's maybe 3 to 6 months tops to finalize everything. Without a will, that's when I see very often when someone passes away intestate without a will, there's a greater likelihood of litigation, legal disputes, because people will step in and say, well, this is what he wanted or she wanted, and this is, because the person never expressed what they wanted, it's easier for people to come out of the woodwork and make claims.
Okay.
But the rule of thumb is if you passed away and you have no kids and you're married, everything would go to your wife.
Right.
If you passed away and you're married and you have kids, the first $300,000, your spouse would have the option of receiving what's called a preferential share. So it would be the first $300,000 of your estate, and then the balance of your estate would be distributed in accordance with the provisions of the Succession Law Reform Act. But it's more. People sometimes, I've had some friends say, "Oh, don't you lawyers? You guys must love it when people do their wills, right?" I go, my answer to that is if people think that it's more beneficial for lawyers when someone comes in and does a will, it is and it isn't, because it's a lot more work for the lawyer and a lot more work for the law firm, which translates to more money for the family when there's no will.
Mm-hmm. Yeah.
And I think the biggest service we can do our loved ones, because we got to keep in mind they'll be grieving, right? And it's tough when you love somebody and they've left, and you've got to deal with these emotions, and you don't want to be doing paperwork and lawyers, and if the person took care of all these things before leaving, it just makes things so much easier.
Many people, even friends of mine, say, "Why am I making a will? I don't have anything. I don't have anything to leave. I don't really have anything." That is quite common. What is your take on that?
Well, I think there's a bank, I won't name the bank, but there's a bank that has a slogan that says, "You're richer than you think." It's true. We don't feel rich because we have our bills and everything to pay and these obligations, and bread is too expensive, milk is too expensive, inflation. But most of us have assets. Most of us have some assets, even if all you have is a car, right? I had a client who passed away, and he had given away his assets during his life because he was, it wasn't a surprise. Everyone knew that it was a long period of illness, and so he gave away a lot of his assets during his life, and people can do that. But he forgot about an old vintage car that he had, and this vintage car was maybe worth $20,000, right? But he wasn't driving it; hadn't been driving in a while, and so $20,000 is a lot of money to me. $20,000 is a lot of money to everyone, most people I know, and so in that particular file, he had to pay more than what he should have paid in legal fees just to deal with that one asset. And so, a lot of us have sometimes bank accounts that we've forgotten. It might be a bank account that you opened up in 1992 and there was $500 in it or a stock, and all of a sudden it's worth $3,000 or $4,000. If you don't have a will, right, and you call a lawyer and say, oh, Stefan, there's this much in my account and can you help me? Well, the thing is, it's the same amount of paperwork to probate a $1 million estate that it is to probate a $10,000 estate. But if your estate is only worth $10,000, you're giving away a big chunk of what your asset is just in fees, which doesn't make sense, right? To me, it doesn't make sense to pay $1 in fees or to recover 50 cents.
Yeah.
Now, another benefit to a good estate plan is that there are a lot of assets that can be transferred to your named beneficiaries without going through the probate process. So there are steps that you can take with certain assets where if you pass away, it automatically gets paid to the people that you've named. And with that, it allows them to have access to funds to pay for things during the 3 or to 6 months it may take to administer the estate. And so when I meet with my estate clients to prepare an estate plan, I go through the types of assets they have, the types of liabilities they have, and then I'll tell them, okay, well, with this is what you should do. Who's your financial planner? Okay, this person, which bank? All right, we're going to write them a letter, tell them to do this. You schedule an appointment, you go over there, you tell them to change this to that, and sign it, it's done. And it saves so much trouble for the beneficiaries and so much money. And the benefit of making those designations for certain special types of assets is that there are a lot of benefits, but one of them is that those funds are not available to creditors. So I'll give you an example of an RRSP. Well, with a named beneficiary in your RRSP, if you have $100,000 in your RRSP, but you owed $40,000 on your line of credit for Bank ABC, technically the $100,000, if your estate is properly planned, the $100,000 could be paid to your beneficiaries without them having the obligation of paying the debt. Now, of course, pay your debts. It's important. It's morally we should pay our debt, but my job as a lawyer is to give advice to my clients that's in their best interest. And as long as it's legal and it's in my client's best interest, that's the advice I give.
What would you say is the suggested age that people should start looking at preparations of these two documents? We're young. When you're young and you have the world in your hands and you don't think anything is going to happen, so what kind of age or time in your life you think?
I would say there are a few times in your life, like there are a few events where you should, I think, automatically do it. One, when you buy a house, number one. When you get married, or if you move in with someone, because if you move in with someone and you may live with that person for a year, but you may live with them for 10 years. And so what was your intention? If someone passes away after 10 years of cohabitation, what was the intention? Was it marriage-like, or was it we're keeping our financial affairs separate? Sometimes these kinds of situations end up in family court. And so I would recommend making your will during major, key life events like buying a house, moving in with someone else, getting married, having children. Having children, if you have dependents under your care, your will also indicate who will be the child's guardian, right? Who will have care and custody of the child if you're no longer alive. And so that's something that's set out in the will. So that has nothing to do with assets or things you own, but it tells the court who you want and who do you trust to take care of your child. In some cases, both parents are around, and if they're both involved and able to care for the child, well, then the child will go to the surviving parent, but that's not always the case.
Yeah. I want you to go back to the living together, moving in with someone, because I think a lot of people are not quite clear or know exactly what happens should that relationship disintegrate or the person dies. because we look at it differently from a marriage. So could you just go over that part about living together? And
it's living together. Deaths or separations for people who are when we have two people in a couple that are living together can be very, very complex, because the only people who really know what the agreement was between them were the people that were in the relationship. You know, you may say things to your sister, your brother, or your friends when you're upset or whatever, but the only people who really know what was the intention was the two people who were in the marriage. So once one person's gone, the other person can say whatever whatever they want. So, and in Canada, couples who are living in a marriage-like relationship, even though they're not married, are more and more being treated like married couples. And in the province of British Columbia, there's actually provincial legislation that gives common law spouses rights that are very similar to the rights of married spouses. And I find a lot of trends tend to go from west to east, and with people, you know, I see more statistics show that more people are choosing to live like a married couple, but without the marital contract. And so they, but when there's a separation, sometimes there's unfair. It has an unfair impact or an uneven impact on the members of the couples. You have one person who's saying, well, we're not married, and you know, I make $200,000 a year, and I'm going to go live my life, and you've been at home, you know, caring for the kids for the last 7 years, but we're not married, so bye. You know, you go in a one-bedroom apartment somewhere, and I'm going to go in a nice house. So that's not really fair.
Right.
And so the courts, there's a lot of jurisprudence, recent case decisions, and principles that have been implemented to protect people, usually the spouse, whether it's the spouse with the fewer assets or the lower income. And so one of the big things, one of the probably wisest investments, legal investments that I would recommend people do if you're moving in with someone is a marriage, like a cohabitation agreement if you're moving in with someone. And if you're getting married, it would be called a marriage agreement. Because it's not unusual. It's not unusual for parties, you know, a man and a woman or two people in a couple to pay between the two of them like $60,000 in legal fees over 2-3 years, fighting in court about what was the intention.
Could have been solved with a will. I wish I could just keep on speaking with you, but our time has come to an end. Thank you. You have given our viewers a wealth of information, and I would like to think that if there are any questions that come in, probably I can pass them on to you. And,
it would be my pleasure.
And then I can pass them back on to the viewers. Thank you so very much again, and
my pleasure, Yvonne.
I hope that sometime in the future we could continue.
Absolutely.
Thank you for watching Caribbean Calendar. We trust that you will maintain your support of our program as we attempt to discuss topics of interest to you. Please offer your suggestions by sending an email to caribbeancalendar@rogers.com.